Good morning, everyone, and welcome to June's risk reduction, risk management class, where we're going to discuss the June 25, which is going to be released on the 24th of June, the new and revised form. I want to take you through, I think I've got about 14 forms. Uh, CAR has 258 forms, in case you were ever wondering, in the CAR library. In this revision, they created 11 new ones and revised 43 of them. So if you look at the list of forms that are either new or revised, it looks pretty long. Some of the revisions and a couple of the new forms are pretty important, but most of them are not that critical. So don't be overwhelmed by by those numbers. And I've selected, along with consulting with CAR and the CAR attorneys, the forms that are most likely the ones that are going to impact your real estate business day to day the most, and want to clarify a few things that might be confusing on those forms. So I'm going to get into it real quickly. Like I said, we've got 14 forms. This class is going to run a little long. There's a chance if it doesn't if it's taking longer than I really want, we may break this into two classes. If I can wrap it up by just being maybe 15 minutes long, I'm going to try to do that. But if we can't finish now, then we'll do part two on Wednesday, the 2nd of July. But if I can finish now, I will. And if some of you have to jump off toward the end, it's being recorded and you've got the handout. So you should be able to access the recording in a day or two and catch the very end of the class. If I do run a little long, if I only have 2 or 3 more forms to cover, the last few forms will be very quick. So I might just hold over just a little bit. I apologize. Hopefully you've got a few extra minutes to hang around. Let's get right into the presentation. Let me share my screen, and been a while. Let's see if I can remember how to do this. Oops, sorry. So can everybody see my screen now?
Yes.
Yes. Oh, okay. Oh, we got it. All right. So now let's get the presentation up. All right. Real quickly, everyone knows how to reach me by now. There are the phone numbers. Email, there's my email address. If you got my old address, it forwards, but this is the best address. And evenings and weekends, call my cell. If you call my cell, I got to tell you, if you call my cell during the day, it rings in my ear now. So that may work better than it has in the past, because I don't need to even look at my cell phone. It'll ring and I know you'll call. I'd still prefer you call my landline, but whatever's easier for you. Number one, I want to be available if you're working, and I don't want to make it difficult for you to figure out what number to call me on. Just call whatever number you have handy and I'll be happy to help. All right, so we're going to talk about just a few of the new and revised forms. Like I said, 14 of them. This is the June 25 release, 25 being the year, this year. But they are being released, they're scheduled to be released on the 24th of June. All right. So the first form I want to talk about is the very minor change to the RPA relative to buyer agent compensation, and a form that's not new, but it was revised a little bit ago. I haven't featured it before, but it might be a form you want to be familiar with. Uh, Neil Kalin is one of the senior attorneys at CAR, and I'm quoting him now. Uh, the changes in the broker compensation with this form release, the changes in the
I mean, I
words
told them
are
that I was here
minor,
now, and
very
it doesn't
small.
matter the time that they come in, but I
The
just, I don't want.
changes, the changes in the concept is huge. And so you'll see, I'll talk about that in just a second. Let me take you through what you already know. You're going to hardly even notice the change, but it is simpler. Let me go right to paragraph 3G. So 3G has been slightly modified. Of course, 3G1 is seller credit to buyer other than the buyer agent compensation, I'm sorry. So all other credits to the buyer go in G1, 3G1. The compensation to pay the buyer's agent goes in G3. And as I've said before, some of you already know this, the reason that's separated, that's an accommodation to lenders and is a benefit to sellers and buyers for that matter, because lenders will not count the compensation a seller pays to the buyer's agent against the maximum amount of credit the loan program will allow the seller to give the buyer. So if you don't separate it, if you put all of the credit to the buyer in G1, including the buyer broker compensation, you're going to run the chance of either maxing out or exceeding the credit allowed. So be sure to separate those credits. G2 is additional credits not listed in G1. Again, not buyer broker compensation. Buyer broker compensation that the seller agrees to pay on behalf of the buyer goes in 3G3, as you all know. And you probably don't have the old RPA in front of you, but if you looked at 3G3 now in your handout or on the screen here, you will see that it's a little simpler than the old version. Of course, for this to apply, you have to check the box, seller payment to compensate buyer's broker, and then list what that amount is. The concept is this has been an evolving situation with buyer agent compensation not being a part of the MLS and not being a part of the listing contract. As you all know, it's now separate between the buyers and the buyer's agent and between the seller and the seller's agents. And there was a lot of effort to create forms and guidelines to be sure that the buyer and the buyer's agent was complying with the NAR settlement and civil code regarding compensation to the buyer's agent. And of course, it brought the seller into the mix because the seller was paying that compensation. For example, as you all know, a buyer's agent is not allowed to receive compensation greater than the compensation listed in the BRBC. That hasn't changed. That is still a part of the rules. However, what has changed is de-emphasizing the need for listing agents and sellers to be involved in policing that. See, it's not appropriate. CAR and with the consulting with NAR has determined, and I think they're completely correct, that brokers sharing compensation that their clients are paying them with other brokers is not appropriate and could in fact be interpreted as an effort to fix commissions. And so, it's not the listing agent's business what the buyer agent compensation is between the buyer and the buyer's broker. That's not of concern to the listing agent. Now, we thought it was, and we're not criticizing the listing agents who made it their concern, because we were saying on the forms, can't be more than what's on the BRBC. Seller has to make an affirmative representation. That's all gone away. It's not the listing agent's concern. It is probably inappropriate for a listing agent through an offer or counteroffer to meddle with the contract between the buyer and the buyer's agent. Yeah, it's probably not appropriate. So another reason why it went away. Another thing is, we're asking listing agents to interpret the way the commission is structured to be sure it complies with the NAR settlement, with the law. And that's not the listing agent's responsibility. So, what it did is it made transactions more complicated, not simpler. So not only did did you have the challenge of, now the buyer's got to pay the buyer's agent. You've got to make sure you take care of that as a buyer's agent through a BRBC, but then you got to deal with the listing agent and the seller and whether or not they believe you're complying to the rules. All of that goes away. The only thing that a listing agent needs to concern themselves about as far as the buyer broker compensation that the seller is willing to agree to or not is the impact on the seller's net. That's the listing agent's job, not to determine whether it's legal, whether it conforms with the civil code or the NAR settlement. That's not the listing agent's concern. It's not something that should muddy up the contract between buyer and seller. So to further what you do want to be concerned about as a listing agent, to make that easier for you, there is a form in the car library. Many of you probably are not aware of it. Many of you may be, some of you may be, and that's the estimated compensation cost for seller. ECCS is also one for buyer. But from this perspective, you get an offer and the RPA says pay 2% to the buyer's agent. So you want to give the seller some guidance as to how that will impact their net. And it gets even a little more complicated when you've got, two offers or more than two offers that, have different amounts that the seller should pay the buyer's agent. So this form will help you better advise your client, your seller, your listing client on what the impact to their bottom line is. Use this tool to explain the impact. And then you can see it's pretty straightforward. You got, 3 different scenarios and you can use multiple forms. And so scenario 1 is, paying X amount. Maybe scenario 2 is paying Y amount. Maybe scenario 3 is not paying anything. And so you can do the calculation and, come up with a net before other closing costs. That's important. Make sure your seller understands. This is just sort of a gross net, if you will. It's kind of a weird term, gross net, but that's what this form will allow you to do. This form will also allow you to do it with a different purchase price. So you've had different purchase price and go through the same exercise again. So that's where you want to focus. Just, get back to the way it used to be, what's going to be your net as a result of this offer. And in the past, we weren't too worried about, the exact amount, the legal structure of how the commission is supposed to be paid or how much is allowed to be. We were just worried about the impact on net. And this sort of gets back to that. Got any questions? Let me know, put something in the chat. But this, I think, is a great improvement, a much better attitude. I'm glad that CAR and NAR have come around to this because I think it's going to make everybody's job a little easier working with buyers and sellers. All right. Now, the next form that it has been extensively restructured. So it looks like there's a lot of red there, but they haven't added a lot to it. But they have reformatted it. They've made it better. They've made it easier to understand and a little more useful in talking with buyers and sellers about the representation of other buyers and sellers. That's what this is. There's a possible representation of more than one buyer and seller in any transaction. And so this form helps you get clarification, and it does a pretty good job also of explaining dual agency. And I wanted to walk you through this real quickly because we do see this more than I'd like, and that is agents not understanding dual agency. Dual agency, or agency, any kind of agency, is broker specific. From time to time, an agent will say, I want to avoid dual agency, so I'm going to refer the buyer to my listing to another agent in my office. That way I'm not a dual agent. You couldn't be more incorrect. You are a dual agent if anybody in RE/MAX Connections represents the other side. So simply having a different person, the agent interacting with the client, if they're both, if Mike is the broker for both agents, it is dual agency. And this form helps explain that a little bit. And in interest of time, I don't want to, read through this form, but I want to encourage you to go through this form, especially when it comes out and you're going to start. It, of course, prints out with all listing contracts and purchase contracts. So, but my fear is that we sort of take it for granted. It's just another form in the pile of paper, and we don't really realize how valuable this form is. So go through it with your client. And the big thing is you want to let sure the client knows that, there may be other clients of the brokerage, other agents who work for the brokerage who have those clients have different goals and compete with each other for the same property or the same pool of buyers. So you want to be sure that the buyer and the sellers understand that. Multiple buyer brokerage, multiple seller, dual agency in any transaction. Now, this is a very good paragraph C, to be sure you understand it and review it with your client, what dual agency is. They've broken this up. I'm a little bit nervous that they've sort of, maybe implied that there are different dual agencies, but there aren't. It's just an explanation of dual agency. And they make it clear that no matter what the situation is, it is dual agency. So broker dual agency is where same broker, but different agents. So the brokerage is considered a dual agent, and they represent the buyer and the seller. Each individual agent working on an transaction is also a dual agent. That's the important point. So you got the same broker, Mike, two different agents. They are both dual agents, but they call that broker dual agency. The term I like is one agent's working with the buyer, the other agent is working with the seller. The agent that's working with the buyer represents the buyer and the seller. The agent working with the seller represents the buyer and the seller. They're dual agents because it's the same brokerage. Single agent dual agency, that's pretty straightforward. Most of you don't have too much challenge when it comes to that. Both the brokerage and the individual agents are dual agents, just like they are in broker dual agencies. See, there's no difference really, but it just sort of says, agents perceive a difference, but it's the same. You're dual agents in either case. So it does a pretty good job. There's an acknowledgement and consent. Offers are not necessarily confidential unless there's a confidentiality agreement, a non-disclosure agreement, NDA. Absent an NDA, now usually there are NDAs in commercial transactions, real common. I've seen many of them over the years. But they're not as common in residential transactions. But there is an NDA if that, in the car library, if that's a concern to a buyer or a seller and they want to keep it confidential, you'd have to exercise an NDA, execute an NDA, because offers can be shared. People often agents don't think that's true, but definitely can. They can be shared with other people. Now you have to have your principal's permission. So the seller receives two offers. And the second offer guy said, "What's your first offer?" Well, I don't want to get a long discussion of the pluses and the minuses of disclosing it. You can make an argument for either one, but before you disclose it, keep in mind the offer belongs to the seller. You'd have to have the seller's permission. The second buyer wants to know what the offer of the first buyer is. Now, this is only when it's not dual agency. If it's dual agency, then you cannot share offers between the clients. Because you have a fiduciary duty to your client. But when you're not the agent of the buyer, for example, you're only the agent of the seller, you could, with the seller's permission, print the offer on the front page of the newspaper. It's not against the law or unethical. All right, so offers are not confidential. There may be multiple buyers and sellers from the same brokerage working on the property. There may be dual agency in the transaction. And by signing, the seller or the buyer, both people get this form, they are in advance consenting to the terms of dual agency. So this is a required form, of course, and one you want to look at that helps understand dual agency. All right, there's been a big change in the FHDS. And, you couldn't make the form more complicated, but it has gotten more complicated, not because Carr or anybody wanted to, but because civil code required it. A lot of people didn't know, but in the original law that created the need for an FHDS, there was a provision that goes into effect July 1. And so the new form is now accommodating that provision. So in some ways, it doesn't change, but in other ways, it changes in a big way. So let me walk you through it so you can see the change. Don't have a heart attack because I'm always available to help you. You'll go through this form. But there is a little bit of a nuance you want to pay attention to. Okay, so so the law applicability didn't change. I mean, they added MHTDS to it because they omitted it last time. But other than that, there's no real change there. No big deal there. Fire hardening, they added something to make it clear. It was always the case, but they didn't really make it stand out. So they added this next line to make it stand out. And that is for properties built on or after January 1 of 2010, there is no obligation to complete fire hardening disclosures. Now, you still have to do the defensible space, which is paragraph 3. But in paragraph 2, if the property is built January 1, 2010 or later, you can skip paragraph 2. And when you see the revision of paragraph 2, you're going to pay more attention to when properties were built. If it's been built, I don't know, in the 70s, well, then it doesn't even matter. But it was built, I don't know, earlier, at the beginning of this century, maybe 15 years ago. Oh, that might be later than 2010, January 1, 2010. So you might want to make sure, confirm when it's built, because it would be easier on the seller, quite frankly, to skip 2 if they can. And you'll see why in just a minute. Okay, so going forward in paragraph 2, the statutory notice didn't change. That's still required. The vulnerabilities, those 6 questions, they didn't change. But what they did add, which is very helpful, is that the seller has no obligation to explain yes or no answers. Unlike a TDS or an SBQ, the seller has to explain when he says yes. But, do you have roof coverings made of untreated wood shingles? No. Or do you have single pane windows? Yes. Explain it. Well, I don't know. I got single pane windows. I mean, so there's no obligation in the law, and they cleaned this up. They made a note. You don't have to put any explanation if you don't want to for answering questions 2B 1 through 6. All right. So other than that, the questions stay the same. Now here comes the big change. Paragraph C, 2C is new, and it was added to the form as required by civil code. Civil code, the original law said that starting July 1 of 2025, the seller has to do 2 things. Provide the buyer, and again, this is only for properties that are in high or very high fire hazard zones, and they are not exempt from a TDS. So you all probably know that. Okay, so the 2 things you have to do is, number 1, you have to provide the buyer a list prepared by CAL FIRE of low-cost retrofit improvements that can harden the property against wildfires. And here's the good news, because the next thing you're going to say is, how the heck is the seller going to know this? Well, they probably won't, but CAL FIRE in the same law had to develop that list. And so it is posted on the net. And so right here on the form, there's the web page, and that fulfills the seller's obligation. The house was built before January 1st, 2010, and is in a very high fire zone and is not exempt from a TDS. Then they do have to provide that information to a seller, and you can provide it by providing the link contained in this form. So that's easy. The more difficult aspect of the law is the seller must answer whether or not he's done any of those improvements, retrofits, if you will, to his house to harden it against wildfires. See, the reason this is exempt from properties built January 1st, 2010 and later, is that became part of the building code. So if you have a house built in 2015, all of these things were required in order to build the house to get the permit. But if you had a house built in 2005 or 1995, many of these things weren't required. So that's why you have to answer these questions on whether or not you have since done that. And so there's a bunch of questions. Now, you can go through the questions. There's 10 here, and then on the next page, there's 2 more. Now, here's the challenge. So did you replace the roof? It doesn't just say, it doesn't end there, with a Class A fire rated roof. Well, a lot of sellers are going to say, well, I put a new roof in about 5 years ago, but I have no clue if it was Class A or fire. And here's the bad news. Again, the law it wasn't written nearly as well as it could be. It doesn't say, are you aware of whether or not it's a Class A fire rated roof? It says, is it or isn't it? So what's the seller to do? Yeah, I replaced the roof, but I have no clue if it's Class A fire rated, and it's 5 years ago, and I've lost all the paperwork. So and all of you on this class, this is maybe the biggest benefit to be here, because this is going to be a problem. Best advice, best guidance, best practice is, unless the seller has absolute affirmative knowledge that his roof that he replaced is a Class A fire rated roof, say no. No, I didn't. Now, maybe he did. He doesn't know. Don't say yes because maybe I did. I think so. No, you don't know so. You don't have the forms. You don't show me the paperwork that says, oh yeah, Class A fire. No, you don't have it. Answer no. Because think about this. No one's going to sue you because the roof's better than you told them. Hey, this is a Class A fire rated roof, Mr. Seller, and you said it wasn't. I'm going to sue you. For what? Taking off a good roof and putting on a bad roof? You won't even be allowed to do it by law anyway. So there's no way you get in trouble when you don't know by saying no. You do have to say yes or no. And some of these questions, they won't have a clue. But it doesn't say, are you aware? So that's the important point. When you don't know for sure, answer no to everything. It's sort of a negative disclosure, if you will. But you're protecting yourself because you're not going to be sued because you told people your house was worse than it is. Yes to any of these questions means it's better than what it used to be. No means nope, just as bad as it was, except maybe it's not, but you don't know. Hope I haven't lost you yet, but that's real important. If you don't know, answer no. Now, the rest of the form doesn't change hardly at all. One little change, don't think it'll affect most of you. So paragraph 3, the defensible space, the one that causes us so much trouble anyway, before paragraph 2 was pretty simple. Paragraph 3 was our challenge. Well, now that you finally mastered paragraph 3, they went ahead and made paragraph 2 more complicated. So now you got more challenges with paragraph 2 to replace the challenges you finally got over with on paragraph 3. But paragraph 3 is the same just as it was before. No change there at all. Now, the one change, paragraph 4, is it does clarify that if you have an inspection report that you obtained as a result of getting a building permit on or after January of 2005, you should provide that report or state where a copy of that report could be found. So that's not going to be real common, but that's the one thing to keep in mind. Okay. This is a new form, and it's a wonderful form, and we're going to require it when it's appropriate. Whenever you're having a seller stay in possession of a property, we're going to have the seller in possession advisory. I'm going to run through this super fast because I want to see if I can't get through all of this today. So, whoops, I really got hit the buttons wrong. Okay. Oh, all right. Now let's get back where I'm at. All right. So the SIPA, Seller in Possession Advisory, talks about the fact that the seller is remaining in the property after close of escrow. There are risks to both the buyer and the seller. And one of those risks is you may be creating a tenancy, even though it's less than 30 days, because civil code is not real clear. And some court cases could complicate whether or not you're creating a tenancy. And the problem with that is the buyer, doesn't want to be a landlord. So he lets the seller stay behind, and he doesn't want to suddenly, because the seller is, quote, renting the property, unquote. Now I'm a landlord, and suddenly tenant landlord law kicks in. So this explains that just a little bit. Another risk is the seller could damage the property during the occupancy. That's happened on more than one occasion, by the way. I will tell you that SIPs are a source of many transactional problems that I deal with, many. So this form, that's why we're going to require it, is going to be very helpful to make sure buyers and sellers know what they're getting into when they do agree to an SIP. All right. Maintenance and habitability of the property. Seller may remain longer than they're supposed to. There may be legal and legal restrictions from allowing somebody to stay in the property because and collecting money. If you let them stay for no charge, it'd be okay. But you're collecting your money. There may be some rent control limits. It doesn't apply as much in the San Diego area because we don't have local onerous laws regarding rent control. We're mostly guided by the state law, which is onerous enough. But in other places in LA and the Bay Area, they have some communities have pretty tough rent control laws. And then, negotiating the terms of seller in possession. This is, when you do this form, you're giving this form to any time the seller's thinking about, agreeing, or the buyer's thinking of asking, thinking of agreeing to it, I'm sorry, and the seller is thinking of asking for it, right? So the seller is the one staying in possession. So, so it will have legal consequences, of course, that's talked about in the paragraph above. But what they say is avoid this. Do not put somebody into a property after close of escrow, allowing the seller to remain with some sentence like this in the RPA. That is so much malpractice. Get yourself in so much trouble. So I'm glad to see that Carr addressed that issue. Do not do that. Use either the SIP or the RLAS for 30 days or more, RLAS for 29 days or less, SIP. Timing issues, the length of occupancy, whether it's 29 days or 30 days or more. Seller early departure, the form reminds everyone that if the seller leaves early, he still pays the full amount, the license fee. That's what it's called in the SIP. That's usually a lump sum, and they are not entitled to a refund unless it's pre-agreed to. What else? Okay, lender issues sometimes happen, not too much. Security for damages, that's the possession fee. We have a lot of problems with possession fees, and what do we do with it, and how do we get it back to the seller, once the seller gives possession to the buyer, and now they want their possession fee that was withheld from their proceeds refunded to them, and that's often a problem. And then verification of property condition. It reminds the parties that the RPA allows for a walkthrough. It goes on to talk about there's another verification, and that's the possession verification, a move in and move out type inspection. So they talk about here, you may want to do two inspections. The inspection, the walkthrough, if you will, before close of escrow, which you should do, and then the walkthrough when the seller gives possession to the buyer. There may be insurance issues, and there may be tax and legal consequences. Another big thing on this form, it makes it really clear that we are not property managers in this case. You're not managing the property. Many of the agents get involved in these problems. My hat goes off to them because they're trying to take care of their clients after the close of escrow. And I think that's a good thing. We don't walk away from our clients just because we got our commission check. You'll be amazed at how many brokerages and agents do that. Well, maybe you won't be amazed, but we don't. The problems after close of escrow, we try to hang around and help them through resolving those problems. But our agency does terminate at the close of escrow. So that's a nice form. Now, another thing that's been changed and improved upon, and you're going to want to really pay attention to this going forward. You have to break an old habit, and that is anytime you want to, modify a contract, you grab an addendum. That's technically and legally not quite right. So cars have been addressing it a little bit, and they've even gone farther now in this form release to clarify a few things about addendums and amendments and revising disclosures, all of that in the next few forms. We'll talk about that. So the first one I want to talk about is the ADM. You're all familiar with it, but it's been modified a little bit and by adding informational language to the form. So the ADM is intended to be used in buyer, seller, and tenant landlord or tenant housing provider transactions. It's not to be used between agents and principals. So in the past, we've been using the addendum to modify a BRBC, or a listing contract. And what they're trying to clarify is that's really not the right use of the form. The form is for buyer, seller, or tenant landlord transactions. Now, if there's any of the other situations, other than this, then use the ADM generic, which you've never heard of before because it's a new form, and I'm going to show it to you here in a minute. Now, the other thing, all of it using generic. Okay, now the other thing is the old ADM had a box on it where you could amend and that's what you really were doing was amending. You weren't adding an addendum to the TDS. So legally and structurally, that whole thing was a mistake from the get-go. And that was just, we did it for years. It was the practice, but it's always not been quite right. They finally addressed that. You do not amend a TDS with an addendum. They've created a form to do that. So you've delivered the TDS or you've delivered the SPQ, and now you've discovered there's a mistake or you need to amend it, you need to correct something on it, you would use the APD. And you've never heard of that form before because it's a new form also, I think. And so we're going to talk about that here as well. Amending a prior disclosure, amending a prior disclosure. An addendum, let me give you a boilerplate or simple definition. An addendum is added to the creation of a legal document. So when you are creating the RPA and you include an SIP, that SIP is an addendum because it's part of the original agreement that the buyer has agreed to let the seller stay there for 2 weeks. An addendum is part of the original paperwork. That's an addendum. It's added. Now, the use of addendums is technically should be less and less and less. Why? Because of the text overflow. Anything you need to say on the form, on the RPA, is probably a blank to say it. And then, you run out of space on the blank, you keep typing, and it adds an addendum to the RPA. Or CAR has some pre-created addendums, and you click on those and they get attached. So addendums are part of the original creation. When you change an agreement, close of escrow is going to be June 30th. Oh, you know what? We're going to stay 2 weeks. Close of escrow is going to now be July 15th. Well, now you're amending. You're not addending. You're not adding to the original agreement. You're amending the original agreement. So that is an amendment. And of course, updating a disclosure is neither. I mean, it's not it may be an addendum. I mean, an amendment. It is an amendment. It's changing the disclosure. But you want to make it a disclosure because it's not something the buyer agrees to. An addendum and an amendment have to be agreed to by both parties. The amending the TDS doesn't have to be agreed to by the buyer, just has to be acknowledged by the buyer. So that's the much better concept. And now the paperwork does a much better job of documenting what I just sort of explained there. Okay, and you're going to see these other two forms real quickly. Okay, now to change the terms of an already existing agreement, use an amendment, just as I'm saying, and that's an AEA. That's been in the library for a while, and a lot of agents are not familiar with an AEA. Every once in a while, an agent will call me and say, I got an AEA from the other side. And I with love say, well, the other side's probably a little bit ahead of the game. they got one on you because they're correct. You're changing the agreement now. You're amending it, and the AEA is correct form to use. All right, you'll see all that in a minute. Okay, now, like I said, an addendum, the addendum, the ADA, is between buyer and buyer or tenant and seller or landlord, housing provider, not between agent and principal. Okay, between the two principals. So that's, it's a signature line. In the past, we were crossing it off and writing the word agent and all that stuff. Not anymore. We don't need to anymore. Okay. So now the AEA, let me look at that real quickly with you. And the AEA is when you're amending an existing agreement. See, that's exactly what you're doing. You're amending it. And, it's pretty straightforward. You identify the property and the parties. There's a bunch of blanks to write what you're changing. And then your request to amend this has an expiration date. If it doesn't have an expiration date, we actually had this happen. One of our agents wanted to amend, but they used an addendum. Like most agents, they didn't realize that the amendment was what they should have used. They used an addendum, and they sent the addendum over to the buyer, and the buyer never signed it. And now, it's a long escrow, 35, 40 days later, the seller has assumed the buyer's not going to agree to it, and the seller made some other provision. Just before escrow closed, the buyer figured out it's in their best interest now to agree to that. And so they signed the addendum and sent it back. And, unfortunately, I won't name names, but the agent called me and I had the sad duty to tell him you're screwed, because, you didn't create an expiration of that addendum. As long you didn't rescind it, you could have rescinded it, but it was floating out there. You thought the buyer was ignoring it. He was. You made other changes, spent money. Then the buyer figured out it's in his best interest to agree to that addendum when you didn't want him to anymore. And now, so the amendment says, okay, we're going to amend this contract, and buyer or seller, whoever you're sending it to, you got until, 5 p.m. on the third day, or you can change it, to agree to this. Otherwise, this is null and void. You can't agree to it a week later without me accepting that late agreement. So it has an expiration, very important, and then it has an acceptance. The other side accepts it. Now, it also has a form where it says it's not accepted, and that's a courtesy so that the other side knows you're not just ignoring me. No, I'm not going to accept this. All right, hope that's pretty clear. Now, the amendment to prior disclosure, that's how you amend a disclosure, is specifically a TDS or SPQ or any other disclosure, but that's going to be the most common one. The transfer disclosure statement or the SPQ. Now, if the property is a duplex, triplex, or fourplex, then this amendment to the prior disclosure, APD, is for all the units or only for the units named. All right. Now, this is, this buyer, the agents are not confirming the amended disclosure, and we're not verifying this information. This is sort of a disclaimer, if you will, to protect the agents mostly. Seller makes the following disclosures. So now you write down the changes. And if applicable, maybe you're only changing one of the paragraphs on the disclosure, on the TDS or the SPQ, so you could check that box. All right, now the important thing is that if you're amending an SPQ or a TDS, you may be giving the buyer, or you will be giving the buyer a statutory right to cancel, because the 5 days would start after the amendment. So that's You still want to make the amendment because, if they're going to cancel anyway because of it, you want them to, because otherwise they're going to sue you, and that would be worse. So be sure that you're aware of that and your client's aware of that. Now, the addendum generic, real quickly, that is simply a addendum in situations where it's not between two principals or a buyer and seller or tenant and landlord. And so it identifies the parties. The two, they are both principals, but they are not necessarily a buyer and a seller or a landlord and tenant. Now, if you're going to modify compensation, this form says use the MTLA or the MTBR. That's a better way to modify compensation. Lots of blanks to write on what you want. And then notice it doesn't say buyer, tenant, seller, housing provider. It says principal 1, principal 2, because the principals could be an agent, one of the principals. So it sort of cleans up the way to use the form without having to strike out a lot of pre-printed things. Okay, a BIE has been slightly modified. And I just want to remind you, this is a very nice form to have. Now, the first thing is, keep this in mind. This BIE is between the buyer and the buyer's broker. There is no duty to share this with the other side. You may want to, the buyer may say it's okay, and you can, but you have no obligation to share this with the other side. This is between the buyer's agent and the buyer's broker and the buyer. And then it talks about the importance of investigating, what the buyer's rights and duties are, and that you're advised to, get the inspections. And if you, don't get these inspections, you're doing it against the advice of the broker. Now, this format has been changed only slightly, but it made it a little easier. The first 3 are the common ones: a home inspection, insurability, and wood destroying pests. And then the rest of them are alphabetically organized. Real simple. Not a big change. Buyer's inspection waiver, they may added that a little bit. They've added a little bit to that to make it a little more friendly and a little more, what's what I want, useful in clarifying that the buyer may be waiving some inspections that have been recommended to him. So the first thing is, just like the BIE, it is not a form between buyer and seller. It's a form between buyer and buyer's broker. And then the importance of doing an investigation, what the buyer's rights and duties are. Now, here are the waivers. So they could waive a home inspection, and if they do, they're going to initial this. If you do, you're acting against the broker's advice. You could waive the pest inspection, and if you do, you're acting against our advice, and again, you initial that. You could waive another inspection. Now, I want to make this clear. Paragraph 3 is inspections that the agent is recommending to the buyer, and they're waiving it. Okay? Now, paragraph 4 is waiver of additional inspections recommended by other reports. So, we recommend you get a physical inspection. The physical inspection says you may want to have an electrical inspection, a roof inspection. Well, that's where you would list these other inspection report, by licensed roofer. That's what, these are, and the buyer doesn't want to get that. No, I'm not going to have a roofer come out and look at the roof. I'm fine. Okay, well, then we got to waive that. And so that's waiver of investigations, inspections, if you will, recommended on different reports the buyer has got. And again, you check what they're waiving. And if they're waiving it, then they initial this rather, and they're doing so against our advice. So that makes this form a little clearer and a little more useful in how you use it to not only waive inspections you want, like a physical inspection or pest inspection, but inspections that maybe others have suggested they should get. They've waived the pest inspection, and they also were told they should get one. I would do both. I recommended a pest inspection, and you said no. That would be back in paragraph 3. And the physical inspection report said that you should get a pest inspection, and you're saying no. uh, it's a double opportunity to get that inspection. Now, later, when it closes escrow and they're infested with termites and they say, my agent didn't tell me, didn't advise me. Well, wait a minute, you signed two waivers. They happen to be on the same form, but they waive both. Okay. The referral fee agreement. I'm going to be able to finish on time, guys. That's the good news, I guess. We'll be not more than 10 minutes long because we're practically done now. The referral fee agreement has been so improved by such a simple change. I cannot tell you, I wish I had $1, maybe more than $1, but $1 would buy me, really nice dinner at a really nice restaurant where agents were confused who's a referring broker and who's a recipient broker. The recipient broker, is he receiving the money or receiving the client? That's the big confusion. So the old referral agreement was a little confusing in terminology. So they cleaned it up. They just common sense, and you'll see what I mean right away. So I identify the parties and the entities. So the referring broker, that's pretty straightforward. Now, I love this definition. It's the broker getting paid for referring a client or a customer. The principal, in other words, you're referring the principal. I'm getting paid for that. I'm the referring broker. All right. And then the referring agent, and then they identify them. The representing broker or representing agent, the recipient agent or broker went away. They got rid of that term. Okay. And so the representing broker is the broker paying the fee and representing the principal. Plain English. This is such a nice improvement. So you're gonna love it when you use this form. You won't have any question. You go right through it. The old form, you could figure it out, but it took a while for you to have to kind of, okay, now I got to get this right. Well, am I the recipient or am I the referring? What am I? So that's pretty straightforward. Then you identify the principal, pretty straightforward. And then the agreement itself, they've made that much clearer as well. And so there's 5 provisions. 4 are pre-boilerplate, and then a 5th one, anything else not covered. So what is the referral fee? And the compensation is owed for what? Buy, sell, lease, other. You can check more than one. Check all that apply. What properties are covered? This is real important. I've had disputes over this. So the buyer buys a house, and then later he sells the house. Because he had to sell it. It was only about 4 months after he bought it. The referring broker said, hey, I get a commission on that too. I referred that client. Well, not necessarily. Yeah, you may be, but now it's got to be clarified on the referral agreement. So what transactions are covered by this? Look at the 2C. Any and all property transactions specified in 1B during the term of this agreement. Okay. Referral period. Usually the boilerplate is 12 months. The timing of compensation, when is compensation paid, and any other terms that you want to add to it. So there's cleaned up a little bit, made a lot more agent friendly, if you will. The referring broker, the representing broker, reciprocal went away. Representing broker, I'm representing the referred principal. Referring broker, I'm referring the principal. I'm getting paid for my referral. I am paying for the referral. See, that's the difference. Okay. Now, additional signature addendum. This has been, as you can see, all the red, heavily modified and very good. Much better, much better. So let's take a look at that, and then we'll be done. I have questions. So this is not an assignment. This is when you have more than 2 people on the transaction on one side. So, you have 4 buyers and you've only got lines for 2 buyers. Then you would use this. You would not use this if you're adding a buyer to the transaction. And so that's made real clear in this paragraph. You would use an AOAA, an assignment of the agreement. The buyer who was the original buyer is assigning it to himself and the added buyer. And the AOA, I won't go through that form on this class, but it's very straightforward on how you do that. This is not adding a buyer. This is used from the get-go because you have multiple buyers. It could be used once a buyer is added, because now you got to have the buyer sign a bunch of forms, but it's not adding the buyer. All right. So don't, be careful not to get confused there. Okay. So it identifies the entities, who the people are, the transaction entities. All right. So you list all of them. So you've got the two buyers you got room for, and you got two other buyers that you had to use this form because you got four buyers. You would list all four buyers here and check buyer. Or you got the two sellers, but you found out, oh my gosh, mom and dad are also on title. They gave son some money, and son and wife, daughter-in-law, they bought the house. All four of them are on title. So now seller, you would list all four sellers. So list all of them. This is the contract between all the people. Same, for both ones. Okay, pretty same. And then what's being signed? For a digital signature addendum to be valid, it has to specifically identify the form being signed, that being added, we're going to add this to that form. You can't just make it for any form. It can't be open-ended. So to make that a little easier, they pre-listed a lot of the situations where you're going to start with all of these people, all these forms, I'm sorry. So the forms being signed, if it's a purchase, there's all the forms. This happens to be the bundled forms. And this addendum, the buyer 3 and buyer 4 signing this addendum, they are signing all of these forms because you've identified them. If it's a listing, there's all the bundled forms in the listing contract. A BRBC, or there's all the bundled forms in the BRBC. Rental agreement, all the bundled forms. A disclosure, either the TDS, the SPQ, or both. And of course, other. So this is very helpful. And then as you have them sign additional forms, you can just list those additional forms as necessary. There's no blanket, additional signature addendum that covers a future form. You have to specify the form that it's covering. So this is very helpful. And then there's a signature line for the additional signers. You could have, 4 on this form, 2 on the originals. You could have 6 people on one form. That's very straightforward. All right. Now, the other thing, little nuance here, right? Civil code says that in order for liquidated damages arbitration to be valid, the agreement to do that, to be valid, the liquidated damages clause and the arbitration clause must be initialed by all parties, the clause. So simply having an additional signature addendum is not going to cover that. You have to specify it's the liquidated damages. Now, you do not need to do this liquidated damages authorization on every form they do. The old form, I don't want to get in the weeds here too much. The old form, it had, a place for this. Does this apply to liquidated damages for every time you did it? It was a little confusing. So what they've done is they've created a liquidated damages and arbitration additional signature addendum to be used in conjunction with the additional signature addendum. And here's how it works. When you check purchase, because it only applies to a purchase, doesn't apply to any of these others. When you check purchase, the liquidated damages and arbitration additional signature addendum will automatically attach. So you'll have both. Okay, so then here it is. Here's the liquidated damages clause, because the clause has to be initial. And there's your additional signers for their initials. Arbitration, there's the arbitration clause. That has to be specifically initialed. And there's their initials right there. Now, to prevent someone who, the other side doesn't know, all right, so this didn't get initialed. Signer one initialed it, signer two didn't initial it, or neither one of them initialed it. Did they just forget to initial this? What happened? So there is a acknowledgement of receipt to be used when you're not initialing the paragraphs. Yeah, I got this, but I am not initialing it. And so you're initialing that you got it. This does not agree to arbitration or agree to liquidated damages. This simply acknowledges that you got it, but you're ignoring it. Hope that's kind of clear. Folks, we did it. I appreciate you hanging in there. We're done. Time for questions.
There's a question in the chat that says, are sellers allowed to offer a bonus to buyer's agents?
No.
Simple answer.
Yeah.
Do we have to use the estimated compensation costs for sellers form? Ningrid already has this in a spreadsheet that she makes for her sellers and she shares
Yeah.
it with them.
No, that form's not required. And Ingrid, good for you. You've already proactively addressed what that form does. The reason I brought that up is you should, in writing, provide the seller the impact of the compensation they're going to pay on behalf of the buyer to the buyer's agent on their ultimate net. And so that form is an easy way to do it. But if you have your own, Ingrid, good for you. So yeah, use your form. I can't tell you how many times, I guess I can tell you, I can't tell you exactly how many, buyer, well, listing agents have gotten in trouble because sellers netted significantly less than they thought they were going to net. And the defense the agent always has is, I explained this to them, but you don't have anything in writing. I would tell you that if you are not providing an estimated net sheet and all of your listings, you're making a mistake. There's plenty of disclaimers you can do. This doesn't include repairs. This allows for only the cost of a termite inspection. Does not. I mean, there's all those kinds of things you can put. This is based upon Mr. Seller, your statement that you owe 400,000. I mean, all of that. But you should review their costs and what their net will be, and do something that memorializes that you had that discussion.
And then Tracy just asked the last question, when are these forms available? And as you said, June 24th.
June 24th. That's the scheduled release. They've struggled with a couple of things, but they've got them, I believe, fixed now. So hopefully they don't struggle with anything else.
We have one more question.
Yes.
Do you have to list all the others forms the additional sellers sign during the transaction?
Yes. Anytime you want to use the additional signature addendum, you must specify what form it is for and the date of that form. You can't have a generic one. This covers all the forms in the file. You have to list the form, and best practice, and that's a great question, by the way. I've been on multiple webinars, some with brokers only, some with certified trainer webinars, and then of course webinars that are available to agents in general. In all of them, the comment was made that best practice is you include the date of the form to demonstrate that that's that specific form and not just a generic whatever form it is they're having them sign. But it's a specific one, the one that was dated June 9th.
Good grief. Walt, it's Libby.
Yes.
Well, that was my question. And so throughout a transaction, people sign bazillions of forms.
Right.
So we need to have,
Bazillions of
list of
ASAs.
every single one.
Yeah. Now, see, you start with, assuming that you're not adding the buyer. You start with, checking the box. This is a purchase, because they're all listed. So one form will cover your RPA and all those other forms that are listed. By the way,
okay.
if you ever wondered what forms are bundled, it's a nice little training or cheat sheet, if you will. You know,
Okay.
the ASA on that page, you know, they list all the forms bundled with the RPA, all the forms bundled with the RLA. And
Okay.
so
That's right.
they have done, you know, your initial homework for you by telling you, okay, these are all the forms you want these second and third buyers to also acknowledge they're signing for them as well, because they're listed on the you know. Now here comes an addendum or amendment, more correctly, you know, 2 days into escrow. Now they want to amend something. You're going to have to specify. You have to get another additional agent signature addendum
Mhm.
and specify in other. That's what the other is for. And you would write amendment dated, you know, June 21st.
So you better know who you're dealing with in the beginning. So
Yeah.
you already have them on there. Thank you.
You're welcome.
That's
Thank you.
it.
All right, folks. Well, thank you for being on the class. Next month, I'm going to get out on a limb a little bit. MLS is going to have made a decision on what they're going to do about clear cooperation. Our local MLS, whether they're going to adopt the NAR policy. I'm pretty sure they are. And I got a great question. I'm going to do some research to make sure I understand, you know, how people are getting away with what we think is breaking the rules. Maybe they're not. But we're going to cover, among other things, we're going to talk about clear cooperation, excluding properties from the MLS, marketing property outside of the MLS, because there is a way. Our MLS, I believe, I haven't checked in a week. You know, my house flooded, so I've been preoccupied, but I haven't checked in the last week. But there is a way. I got a call from an agent yesterday, and I didn't want to say anything because I hadn't confirmed that they had. You can market property according to NAR, even though you've excluded it from the MLS, and you're not susceptible to clear cooperation for up to 30 days. And it sort of is an office exclusive. But I don't know that our local MLS has adopted that rule yet. 2 weeks ago, they had not, because I made the inquiry. I should have inquired again, because I do these kinds of things all the time to stay abreast. But I did get preoccupied. But I'll check on that. And our next training, though, we'll go into that in quite a bit of detail. So you'll want to be here, and you'll want to tell all your friends and neighbors to be there too.
Thanks, Walt.
Thank you. Have a great,
Thank
great
you.
day, everyone.
Bye,
And
everybody.
wish me luck on finding a place to live. I'm tired of
Thank
the
you, Walt.
Good luck.
Good luck.
Bye.
Good luck,
you.
Walt.
Thank you.